Okay, welcome today, 16th of October, to this meeting that I've called. Well, I'd like to take apologies, I gather. Apologies.
Mr. Mayor.
You can refrain from that sort of comment, thank you. Conflicts of interest? Conflicts of interest? Any conflicts of interest?
Yes. I need to do confirmation of the agenda.
Confirmation of the agenda, I'm sorry. Okay, I'll move that. Can I have a second for confirmation of the agenda? Councillor Williams, thank you. Those in favour, raise your hand, say aye. Against, motion carried. Okay, conflict of interest. Is there any conflicts of interest to be declared?
Yes, so I have a potential conflict of interest depending on what we do with the motion or whatever the motions may be in the publicly excluded part of the meeting. I believe that I have a non-direct pecuniary interest in whether the decision is to try to stop the election results being declared or otherwise. Being one of the candidates for re-election, similar to a number of other councillors, including yourself, around the table, and I understand that that's unlawful under Section 6 of the.
Councillor Paniora, are you declaring a conflict or not? I'm not. I don't need a statement from you. Just to clear whether you have a conflict or not, please, and we will record it.
For clarification, CE Maris, can you give us some information around whether we are breaching the act that I sent to you last night around the decision today? Do you have any comments on that? Because I don't know what we're going to be moving in the publicly excluded agenda. So I'm unsure whether there is a conflict of interest, a pecuniary.
Mr. Mayor, what I suggest we do is that we can declare conflicts at each item as well. And so we can have that conversation at the PICs and public excluded item, and we can clarify that then.
Up to individual members to declare whether they have a conflict. So you want to declare a conflict?
Is that right?
Councillor Paniora has declared a conflict. Anyone else wish to declare a conflict?
Well, it's not apparent, so I'll take the advice.
All right. Okay, the next is I move into publicly excluded session.
Mr. Mayor, if I could just say on the open agenda, the next item is the same item. There were a number of questions from councillors regarding the process here, and let's give them the opportunity to ask those questions. So I suggest you open it up to the floor for questions.
The questions to whom?
It's up to the council.
So what are the questions?
Question of excluded.
You wait your turn. You'll be asked when you put your hand up. Councillor Vincent.
I just seeking clarification that we are having some question time regarding whether or not to exclude the public from the meeting.
So through you, Mr. Mayor, so that will be the next item. When you move to public excluded, you can have a debate and ask questions at that point on moving into public excluded. Is there any other process questions that elected members have sent through or want to ask? Well, this is the opportunity.
Yeah, so my question is around whether this is comes within the definition of an emergency. Is it an emergency meeting that is procedurally correct?
Through you, Mr. Mayor, and we'll get Warren up, I think, to the front. And I'd just like to introduce Warren Bangler, Simpson Aggression. I'm just going to give Warren a minute or two to get around to the front, and Kelly, I'll get you to switch out if I can. Thank you. Warren, you comfortable answering this question? It's around, the definition of urgency and whether this meeting is urgent.
Thank you, Mr. Mayor.
Dagmar, what have you got to say?
Look, in response to the councillor's question and Mr. Maris's invitation to speak, the Mayor has the ability to call an emergency meeting under Clause 22A of Schedule 7 of the Local Government Act. However, there are prerequisites that must be met in order to exercise that power. As set out in the legislation, there's a requirement that there be an emergency, and in particular that the business which is being discussed at the meeting cannot be, it has to be dealt with basically at a time earlier than would be the case if an extraordinary meeting was called, for which there's a requirement of 3 working days' notice. So, inherent in that, there must be a degree of urgency in the business, and something which, I guess, in the present circumstances, must be dealt with today.
Follow-up question, Chair.
What is your further question?
So based on the information that you've been provided with in terms of the substantive complaint, is that consistent with what you have just described as the definition of the requirement for an emergency meeting?
Mr. Maris, are you happy for me to continue? I understand the substance of the business that is before the council is Mayor Jepson wishes to seek the council's approval to lodge a complaint and to seek advice from the Department of Internal Affairs. While there may be different reasons that His Worship the Mayor wishes to do that, in my view, there is no immediate time requirement that needs to be met.
Thank you.
What does that mean? The public are not excluded?
We haven't excluded the public. We're still on question.
Whether we should have a meeting or not?
Yeah.
Okay. No, I'm not going to take a question. You don't want to sort this out. Okay, you can have a question.
Well, my question is very basic. We have been given this information now, and if we look at the background information, I don't find anything after October 6th, which is like 10 days before, and why we were not informed of this sudden, and what is the motivation for this meeting at the last stage when we are like next to next cliffhanger situation. This whole premise of having a transparent consult is hijacked by this whole saga of not conveying anything to us for since 10 days and the last minute. So the very basis of transparency is not there. So what's your comments on that?
Mr. Mayor, I don't think our legal representative can rightly answer that question. I think the question is more aimed at perhaps, or could be questioned of the person who requisitioned the meeting.
Sorry?
That's a question for the mayor.
I am asking the electoral officer and the legal, the two
Repeat
people.
your question then, Councillor Nair.
Okay, I need to know what's the driver for this whole thing. Because you have been engaged. I hope you were engaged before this as well.
Thank you, Councillor Nair. You've asked the question, and that question is to be directed to the mayor.
Yep.
The mayor was requisitioned the meeting. We can't possibly answer that.
Okay, the mayor can answer it. Somebody has to answer the question.
Okay, if you go through the standing orders, that process calling an emergency meeting, the notice of the time, place of emergency meeting, the matters in respect to which the emergency meeting has been called must be given by the person calling the meeting or by another person on that person's behalf. The notice must be given by whatever means is reasonable circumstances to each member of the local authority. Where an emergency or extraordinary meeting of the local authority is called, but the notice of the meeting is inconsistent with those standing orders due to the manner in which it was called, the local authority must cause the meeting and the general nature of business to be transacted at that meeting. The public will be notified as soon as practicable before the meeting is to be held. So I'm publicly notified as soon as practicable in the circumstances.
It's 10 days.
So you've had proper notification. The nature of the business to be transacted has been put out there to you. And the reason why the meeting has been properly notified has been given. So that's my answer to that. Councillor Erin Wilson-Collins.
Thank you. Hi, Warren. Thanks for making the travel up to meet with us today at such short notice. My question is around the agenda itself. I don't know if you have a copy of that. Not the contents of it as such, because that's public excluded possibly. But my questions are around, again, so we're under emergency. We've received a document at 2:30 this afternoon, which is 3 hours before this meeting was meant to convene. Can you provide advice in regards to Part 6, Section 77 of the Local Government Act regarding requirements in relation to decisions and how we could possibly meet those requirements of exploring all the options available to us and the advantages and disadvantages at this point?
Yes, look, thank you for that question. The councillor is correct to point to those requirements in the Local Government Act. Look, all I think I can say at this stage is, look, when meetings are called using emergency powers at short notice, look, that does create issues in terms of council's agenda, and as I understand from working with the CE, Mr. Maris, it hasn't been possible in the time available to prepare a report documenting those requirements in the normal way. And as the council's legal advisor, I guess all I can say is that does create potential risk of challenge to any decision making by the council.
Okay.
Okay, can I ask you a question then myself, Mr. Bagner? During the course of my 3 years, we've had agenda items and items come on our agenda by staff and other people, not by myself, that come on the day of the meeting. What is the difference?
Through you, Mr. Mayor, I think it's a question for me.
No, it's not for you to ask. I've asked.
Well, no, I think I can answer this question because you're talking about staff reports, I believe.
Talking about lots of information we end up with on the agenda that is not
Staff
ready or available when we have a 600-page agenda come on our table.
So staff reports are always presented to you on the agenda. If they come to you outside of that, you agree as a council that it's extraordinary business. Staff reports are always done on the template with the options and the advantages and disadvantages as required by the Act.
So the point is, Mr. Bagner, it's not unusual, is it?
Sir, all I can say in terms of the council meetings that I've attended, we are reports prepared by council officers, as Mr. Maris has indicated. There is a council template for that, which attempts to follow and meet the requirements of the Act.
So to follow up on my original question, the agenda item that we have is clearly not prepared by staff. They've prepared a cover page, but they haven't prepared the agenda item itself. So that in itself could open us up to risk, as you were describing before, because we're not meeting those requirements for making a decision under the Local Government Act.
That's all they're prepared.
The Chief Executive Maris has done what he can in the time available, but your answer is correct.
Thank you.
Councillor Vincent?
Thank you, Mr. Mayor. I'd just like to clarify the emergency thing, and I have circulated this question earlier, so it shouldn't come as a surprise, but it's just a different way of trying to get an understanding of it. Why can existing legislation not deal with this issue if there are indeed concerns about irregularities in the voting? Or put it another way, are there existing legislative provisions which would enable such a concern to be addressed without the need for this meeting to take place?
Sir,
The electoral officer might want to answer that.
Mr. Maris?
So Dale, are you there?
I am.
Did you hear the question?
I did. So
All right.
under the Local Electoral Act, can you hear me?
Yep, we're good.
Under the Local Electoral Act, following the declaration of results, there are two actions that a candidate or any 10 electors can take. And that is within 3 working days of the declaration of result, a candidate can seek through the district court a judicial recount. And the second one is after 21 days following the declaration, a candidate or any 10 electors can seek an applicant or apply to the district court for a judicial inquiry. So they're the two legal requirements under the Local Electoral Act.
Just to clarify, if I may, Mr. Mayor, it sounds to me like, given the nature of the concerns that we have in our public excluded agenda, the second option would be a more appropriate way to address that, do you think?
Yes, in my view, yes.
Okay.
Yeah.
Question.
Yes.
Mr. Williams, I mean,
Not my name.
Phyllis.
Thank you. I think I can ask this question. Or maybe I can't ask that question. Oh, I think I can. How public is what we're discussing in the public excluded? Yes, that's the letter that the mayor sent us, calling the meeting as public. Yes, okay. So the question is, because in that letter, it's talking about seeking approval to lodge a complaint and request for an investigation. If the council endorses that, who is paying for it? Are there any costs? What is your question, whoever?
Can you just repeat that question for me?
If council authorises the mayor on behalf of council to lodge a complaint and request for an investigation with the relevant authorities, what cost would be involved in that and who would have to pay for it?
So the resolution that's been moved talks about, and when it's in PEX, talks about going to DIA. That's been out in the public arena. I've seen that today, so I'm comfortable to speak to that. As the electoral officer has said, that is not the correct formal process to object to an official declaration. I'll get to your answer. In my view, it's outside the process, and it is simply the mayor, if this passes, will have the opportunity to do that tomorrow before he's out of office on midnight Friday. I don't believe there'll be any costs incurred by Kaipara District Council through this process.
Okay, so the follow-up question, if what we decide today is then challenged, would there be a cost to this council?
Well, in answer to your question, I agree with Mr. Maris. There's unlikely to be any costs incurred invoice to the council from DIA. I would be speculating if there was any legal challenge made to the council's decision making today, the council would, of course, in the normal way, incur legal costs depending on that legal challenge. But it's of course speculative as to whether or not the challenge would be lodged.
So can I just clarify, just for my own understanding, before we move on? Would there be any staff time having to be spent on this matter?
If it is agreed, sure. Yeah, absolutely. But yeah, it's minimal, it's soft cost, right?
Okay. So then just to be absolutely clear, what we're asking today is to make a decision that doesn't meet the requirements in relation to making decisions in the Local Government Act, to endorse the mayor to make a complaint that is not the actual channel to make a complaint, which would open us up possibly to a judicial review that could incur legal costs for this council, when in actual fact, anybody could just make their complaint through the correct channels and go down the path.
I don't think we can answer that question.
I think you have. Thank you.
Okay,
Which one?
Councillor Howard first.
Thank you, Mr. Mayor. So I'm pretty frustrated. But however, what I can remember where I was going. We've got these situations that aren't prescribed in the Act. No, and that's clear. That happens after the event. I don't think that's fine. But what I'm keen on is that there are examples presented here of theoretically, I'll use the word going to provide at least an interpretation by some. I think as a council, I'd like to think that we would have an absolute view on the transparency and the integrity of the whole process.
Is this a statement?
Well, it's leading
Please
to.
not interrupt. Councillor Howard, you've had yours. Do not interrupt them, please.
So what I'm keen to understand, if that's the case, is that where does the council actually sit on and out of this on making sure that we have an absolutely true, high integrity, robust system without approach. And I suspect that one way or the other, that could just be left out and not touched on, just nicely pushed up. If it, I'm not suggesting that there is, I'm just only going on the evidence that I can't talk, or we can't talk about, but I want to make sure that we have a really good council of open transparency and integrity on all things. Convoluted question.
So through you, Mr. Mayor, I think that's pretty well to answer. So I'm going to call phone friend, get our contractor in, Dale Foster, and an electoral officer. Dale, are you there?
I am, and I heard the question. I think, in short, the electoral process will continue. I will declare results tomorrow, and those results are able to be challenged through the legislative requirements of the Local Electoral Act. And I think that just sums it up from the electoral officer's perspective, reading the legislation.
I have a quick one.
No, I'm not going to.
This one is a very quick one. It's really important.
Okay, one more question for you and from you, and then I'm going to move on.
Thank you. So given everything that we've heard from Dale and yourself, why are you not just providing this complaint in a personal capacity?
You're not asking me a question. You're asking either Warren Bagner or Dale or the Chief Executive.
No, I want to ask you.
No, you're not going to ask me a question. I'm not going to be answering your questions. Ask a question.
Council through the mud for your own.
I'm not going to respond to those questions. You're out of order. You want to ask those questions, I will just ask you to leave. So I ask you as the members of the public to leave the meeting too if you get out of order. But the whole purpose of this meeting is because I have seen a huge number of irregularities in the way this process has been operated. And I'm not happy with it. I want to see that New Zealanders, not just our corporate district people, but New Zealanders get to have a fair process.
Why are you keeping it in the
Sit down.
public?
Sit down. You're not able to come up and stand up here. Sit down. Take your seat. Okay. Take your seat, please. This is not a place where you can come and do this. Take your seat. Okay, we're going to adjourn the meeting till tomorrow morning. Thank you.
What time?
Full time.
Yeah.
We're here, 9 o'clock in the morning.
The heat was on, eh? You can't stand the heat, get out of the kitchen. As they say.
It's the in mouth.